Federal Law Section. The Truth in Lending Act is a United States federal law designed to protect consumers in credit transactions by requiring clear disclosure of key terms of the lending arrangement and all costs. The Federal Trade Commission enforces and administers the Truth in Lending Act. Truth in Lending also gives consumers the right to cancel certain credit transactions that involve a lien on a consumer's principal dwelling. The borrower usually has the right to rescind the agreement until midnight of the third business day after the promissory note was signed. The lender must disclose to the borrower the annual percentage rate, APR. Annual percentage rate, APR, is an expression of the effective interest rate that the borrower will pay on a loan, taking into account one-time fees and standardizing the way the rate is expressed. In other words, the APR is the total cost of credit to the consumer expressed as an annual percentage of the amount of credit granted. APR is intended to make it easier to compare lenders and loan options. At the urging of President Lyndon Johnson, Congress passed the Federal Fair Housing Act only 1 week after the assassination of Martin Luther King, Jr. on April 11, 1968. The 1968 Act expanded on previous acts and prohibited discrimination based on race, religion, national origin, sex, and, as amended, handicap and family status concerning the sale, rental, and financing of housing. Jones v. Alfred H. Mayer is the United States Supreme Court case which held that Congress could regulate the sale of private property in order to prevent racial discrimination based upon the 13th Amendment. When the Fair Housing Act was first enacted, it prohibited discrimination only on the basis of race, color, religion, and national origin. In 1974, sex was added to the list of protected classes, and in 1988, disability and family status were added. The Americans with Disabilities Acts of 1990 is a wide-ranging civil rights law that prohibits, under certain circumstances, discrimination based on disability. The United States Department of Housing and Urban Development is the cabinet agency with the statutory authority to administer and enforce the Fair Housing Act. Examples of violations of fair housing are steering and blockbusting. Steering is the illegal practice of channeling home seekers to particular areas, either to maintain the homogeneity of an area or to change the character of an area, which limits their choices of where they can live. Blockbusting, which is also known as panic selling and panic peddling, is an illegal racial discrimination practice wherein real estate brokers attempt to change the racial composition of a neighborhood by encouraging listings and sales in a neighborhood. In short, fair housing is the elimination of discriminatory practices and policies in the housing market. The Interstate Land Sales Full Disclosure Act is a federal law which regulates the sale of land in any development that exceeds 25 lots and is being sold across state borders. Now we'll discuss the Sherman Antitrust laws, which prohibit price fixing, group boycotting, the allocation of customers or markets, or tie-in agreements. Price fixing is prohibited. This means that competing brokers, real estate governing bodies, or multiple listing organizations cannot agree to set sales conditions, fees, or management rates. Group boycotting is also illegal under the antitrust laws. This means that 2 or more brokers cannot conspire against another business or agree to withhold their patronage to reduce competition. The allocation of markets or customers would occur when brokers agree to divide their markets or customers and not compete for the other's business. Tie-in agreements are also illegal. For example, a real estate broker owns 10 acres of vacant land. A builder wants to buy the land, but the broker refuses to sell unless the builder agrees to list the property with the brokerage firm. This tie-in arrangement is illegal. An individual may be fined a maximum of $100,000 and be sentenced up to 3 years in prison, and a corporation may be fined up to $1 million for breach of the Sherman Antitrust laws. In a civil suit, an aggrieved person may recover up to triple the value of the actual damages plus attorney's fees and costs. This concludes the section on federal law.